With me today is Bobby Jahal, our Head of Technical Matters in the UK. Bobby has been leading the consultants tracking AIFMD developments for nearly 2 years now, and this year has focused on our analysis of the directive and development of our new AIFMD-ready compliance materials. Bobby, your topic is called Beyond Marketing. What do you plan to cover today?
Thanks, John. Hello, everybody. I plan to look at the requirements non-EU managers are going to need to comply with under the AIFMD when they are marketing under national private placement. Disclosure, investor and regulatory reporting requirements have been applied to non-EEA managers, providing a level playing field with their European counterparts. Managers will need to meet these requirements ahead of 22nd of July 2014 in the UK at least. In the meantime, again only in the UK, funds can be marketed in the UK under transitional provisions, but these do of course run out at the end of that phase in July 2014. So my focus will be on how the AIFMD affects managers, really marketing in the UK. That will be my focus.
Okay, and also with us is Cathy Brown, who's founder and CEO of Global Sales Compliance based in London. Global Sales Compliance has been advising clients since 2006, offering compliance consultancy and cost-effective guidance on marketing products and services overseas. Clients include global financial institutions, alternative fund managers, asset management boutiques and third-party marketing platforms, and firms that find and appreciate the hands-on approach and approach to solving complex regulatory issues. Cathy has 22 years experience in the financial services industry, including 19 years banking experience in Europe for global financial institutions, including Citigroup Alternatives, UBS and Zurich Insurance, as well as wealth management experience at a family office. Cathy, Fortress Europe is your topic. Is it really that bad?
Thank you, John. Well, it could be if firms either get it wrong or do nothing at all. Europe could effectively be closed to them. But the real picture is obtained by looking at where the different EEA member states have got to with their AIFMD implementation plans, transitional periods, how these are being applied, private placement, and reverse solicitation is also an issue. We will discuss in my presentation a 3-step action plan on what non-EEA AIFM should be doing now to continue marketing their funds in the EEA.
Thanks, Cathy. Look forward to that. I'd like to first start with a few reminders on what AIFMD is. Now, the AIFMD applies to all managers of alternative funds operating in the EU and marketing in the EU regardless of the domicile of the fund. AIFMD is not simply one directive. What has been implemented is the Level 1 directive passed by the European Commission and adopted into national law with limited discretion at country level. The Level 2 implementing guidance, drafted by the European Securities and Markets Association, or ESMA, and approved by the European Commission, and that seeks to address gaps and provide clarity to some elements of the directive itself. And thirdly, we're implementing guidance and consultation that's been provided at national level, in the UK produced by our own Treasury and Financial Conduct Authority. Now, this implementation is really accelerated now in 2013, despite, though, as I mentioned, the origins of the directive going back over 5 years. Now, the EU recognised early on that it could not regulate the funds itself, so it sought to regulate the managers instead. The EU already had a structure of regulation for collective investment schemes, that's UCITS, and the AIFMD in many respects is similar to that model. Essentially, any fund that is not a UCITS scheme is potentially caught by the directive. There are limited exemptions for managers that manage less than €100 million or €500 million on an unleveraged basis with a minimum of 5 years lock-in. The exemptions are from registration as an AIFM, not from registration for marketing purposes or registration for national supervisory purposes. Now, the impact of the AIFMD is far-reaching, and managers need to consider implementation carefully, both strategically and for practical delivery reasons. I've listed on this slide just the areas that we think are affected by the directive, and the items in bold are those impacted even where the manager is only marketing in the EU state under the directive, and Bobby will speak to these in a moment. The broad impact on managers is one reason why Cordium is encouraging firms to undertake an assessment of their own state of compliance with the AIFMD and plan their implementation programs carefully. And so the road to July 2014, this too is focusing minds on AIFMD implementation. While a handful of firms will have become authorised early, we expect the majority to wait until 2014. Recently, the UK FCA has indicated it expects firms to be authorised by the 22nd of July 2014, which, with 3 months permitted to authorise a firm and a further 3 months allows the regulator, if there are errors in the application, means there is an effective deadline for firms to file their applications by 22nd of January next year. So, time is short to ensure managers are authorised under the directive. Bobby, what does this mean for firms that simply want to continue marketing?
Thanks, John. So let's address some of the compliance challenges presented by the directive. That's what I shall be covering. So if we start. So following the implementation of the AIFMD, a non-EEA manager seeking to market non-European based funds into Europe must endeavour to understand the directive's impact on a member state by member state basis. Each EEA state must implement the AIFMD into local law, and the target deadline, as we've mentioned, is the 22nd of July 2013, which Cathy would explain later. Many have met, but some have not. So whilst the AIFMD seeks to create a harmonised regulatory regime, in reality, the differentiated implementation, both in terms of transposition and timing and application across Europe, presents somewhat of a challenge for managers. There is no single pan-European answer, and you'll hear that refrain quite a lot. It is thus imperative that firms set out which states that they are active in and engage with specialist local legal counsel in respect of each of those jurisdictions. So, while some non-European managers have taken a rather decisive step in stopping marketing in Europe, it's important to state that whilst the path is certainly bumpy, it's by no means closed. So, what should one actually do? Firstly, the most important question, do you actually market in the European Economic Area? Excuse me. If the answer to that question is no, then you can relax. You're out of scope, pretty much. As John sets out in his introduction, the directive captures those who manage and or market in the EEA. So if the answer to that question is yes, and you do market or intend to market at some point, you should determine which of your offerings is an alternative investment fund, or an AIF as is the acronym that we'll use, in the context of the directive. Again, as has been mentioned at the top of the webinar, in short, the directive covers a range of fund types and strategies, including the ones I've listed there, so managed hedge funds, private equity, trusts. So really the range. So it's fairly wide in its scope. However, there is one exemption, and broadly speaking, the management of single investor vehicles, i.e. segregated or managed accounts, is outside of scope of the directive. Excuse me. After which the firm should then ascertain whether or not a given jurisdiction has implemented a transitional phase and any attendant limitations. The directive provides, it's hardwired into the text, a transitional phase of 12 months, so therefore July 2014, but the application of that transitional is largely determined at EU member states, and so varies, and actually does vary to some degree. Cathy will discuss the state of implementation in a little bit more detail later, but in general, it seems to be the case that a firm must have marketed an AIF in the given state prior to July, or grandfathering as Cathy will refer to it, in order to access that state's transitional. The UK regime, in particular, is quite relaxed. I guess this is part of a concerted government effort to retain and indeed attract business to the UK. It allows firms to market a fund, an AIF, in the UK, so long as that firm has marketed an offering in the EEA. Some states, however, are only allowing specific pre-existing offerings to be marketed, and transitionals may also be differentiated, and actually do seem to be, by whether or not the firm is what's called a full scope, or fully within the scope of the directive, or a sub-threshold, or a manager that meets the de minimis levels that John mentioned. Those kinds of firms are outside the scope of the directive, of course, but certain member states may choose to apply certain AIFMD-derived obligations, nevertheless, as actually is the case in the UK. So whilst many states view the AIFMD as an opportunity to review their private placement regimes overall, it seems to be the case, the ultimate purpose of the directive is to transform and standardise private placement across Europe. But of course, it's important to note at present there is no such thing as a single European private placement regime. It simply doesn't exist. What you have really is a complex and state-specific tapestry, which the directive does ultimately seek to harmonise, and that is the idea eventually. Whether or not they'll actually attain that is a separate question, of course. But in the meantime, states are allowed to retain their private placement regimes until at least 2018, and again, that's hardwired into the directive. So where that does remain in place in a given jurisdiction, firms are able to market as currently, or in a way differentiated by the fact of the implementation of the AIFMD and the transitionals. Again, my favourite phrase, the precise nature of those obligations really do need to be checked on a member state by member state basis. So actually being authorised in the directive is not possible until potentially, this is only potentially until 2015, and therefore to have access to the pan-European passport to market freely into Europe. And that's not possible unless a firm has a physical presence in the EU. And that entity, wherever its status of incorporation is, must be authorised by that home state under the AIFMD, and it will, of course, then, therefore, be subject to the directive in full. Broad anti-avoidance measures, popularly referred to as the letterbox test, mean that the entity must be able to demonstrate that that entity is, in the very least, capable of performing either investment management or risk in respect of that AIF that it intends to market in the EEA. In essence, I guess the idea is that the entity must have real substance and demonstrably so. So, turning to the specifics of the UK regulatory environment post-July 2014, that's actually a deadline, so to sort of make sure one's compliant by that time. A non-EU manager should consider how it will plan for adherence with a range of requirements, which we'll get into now. So firstly, first order of play really, the funds will have to be, funds offered in the UK will have to be registered on the UK's private placement register, which is not actually a public register. It was going to be, but is not, via one of three forms, two of which are relevant for third country or non-EU firms. Most commonly, for those for those who are deemed full scope firms, it'll be an Article 42 form. There's also a secondary form for sub-threshold managers, the small third country form. Those forms require a certain degree of detail, not so much, but there is nevertheless some detail required, including on the domicile of both the manager and the AIF, its use of delegation, custodian, information about the valuation policies, and then the agents used, the prime brokers, counterparties used, and in respect of the small third country firms, information about the strategy of the fund, that is to say, its main category of assets, markets, and use of leverage. In respect of the process, we understand from the FCA that marketing may commence once a valid notification has been submitted. So, a very important point, the process is really one of notification rather than approval. So, thus, a valid submission will generate an automated response, and from what we understand, from that point forward, you are good to go. And that will, though, shortly be followed by an invoice for a notional fee, which we mentioned just at the bottom there, and a notification number for that AIF, which firms may actually wish to append to their marketing materials if they wish to. And as I've said, there is actually an initial charge for registering your fund of £250 for a larger manager, £125 for a small one, and then there is a periodic fee also differentiated according to the size of the funds. Of the manager, beg your pardon. There's also an annual report that must be provided for each AIF that's marketed, and this has to be made available in each jurisdiction in which that AIF is marketed. There may be questions about translation, may also be important there too, into the host state language. This report has to be provided within 6 months of a fund's year end, and it should be made available to investors and the regulator as required. And that report should include fund accounts, so balance sheet and the profit and loss, and a general report on activities of the fund in the year. And it also probably raised an eyebrow or two amongst those who are not so familiar with the European proclivity for making rules about remuneration. There are also requirements around including data on remuneration within the annual report. It's important to note that the remuneration disclosure is not a public disclosure. That may be an important point. Nevertheless, it does need to be made to your investors and the regulator. And the disclosure here, in respect to remuneration, will pertain to staff who perform a function for the AIF, marketed in the EA, and will need to include total remuneration of those staff, i.e. the fixed and the variable remuneration, the number of beneficiaries, and the aggregate pay to senior management and staff having a material impact upon the risk profile of the fund is the way it's characterised, which is understood to mean portfolio managers, traders, the compliance officer, importantly, and heads of business units are also categorised as senior management and all those having an impact upon the risk profile of the fund. The fund itself should also be audited, which may be forced if it's not already required in accordance with the home state rules of the fund. There are some specific initial and ongoing investor disclosure requirements also, so one probably needs to engage with your lawyers about updating your offering documentation to ensure that it suits to be compliant with the directive. And much of this is probably already enclosed within those documentations, within that documentation, but nevertheless a comparison will have to be made between existing materials and the AIFMD's requirements. So there's a few, and they're listed therein, but they include some information on strategy and objectives, your assets, risks, restrictions, some narrative about your valuation policies and procedures, liquidity, use of leverage and the actual maximum leverage set, some information on service providers, fees and charges, and information in respect of the overall high-level obligation to meet the requirements on the fair treatment of your investors. So this is really talking about the use of side letters and redemptions and any preferential terms that may exist for certain types of investors. There are also periodic investor disclosure requirements, ongoing obligations which may be made in, for example, in your fact sheets or perhaps your DDQ. Again, some very specific items required here, including percentage of the fund's assets which are subject to special arrangements, again, the use of side pockets and generation or creation rather of special share classes. Any new arrangements for managing the liquidity of the fund, its current risk profile and risk systems employed by the fund manager. If there is leverage employed, very importantly, there's some additional disclosure requirements around that are required as on a regular basis. One of those being if there's any changes to the maximum level set and the total amount of leverage that's employed by that particular fund. There are, of course, also attendant obligations in respect of reporting to the regulator. A key challenge will be compliance with one certain part of those, and that's one of the most challenging parts of it, I should say, is what's called the Annex 4 report, also commonly known as systemic reporting. This thing is due quarterly. This report is due quarterly if the manager has more than $1 billion assets under management, 6 monthly otherwise, although it's annually if you're a private equity closed-ended type vehicle. A lot of information is required covering such things as principal markets, instruments in which the AIFM trades. So this is the report at the level of the manager rather than the fund, which AIFM trades on behalf of the AIF it manages, as well as principal exposures and most important concentrations for each fund. The report is considered to be a European version of Form PF, which is also familiar to the folks in the US, only a lot more onerous, and represents a really significant operational challenge There really is vast amounts of data required, and it's likely to really be needing to be compiled from multiple sources, both front office, back, middle office, and administrator, risk system. So it's really not just a compliance project. That's very important to stress. The requirements are far wider and broader than that. It's really a data gathering and submission exercise. So really, it's very important to start to understand what this report looks like and start making any attendant operational changes as required. So we recommend that firms should really be engaging with their administrator and prime broker counterparties also to assist, but it's important to understand that they can't necessarily rely on those counterparties for a solution, though it is noteworthy that some third-party solutions are beginning to emerge and present themselves. The precise timetable for implementation reporting is yet to be finalised. It's likely to be in place by July 2014 next year, when many non-EEA firms have to register. So again, a further slide on reporting to the regulator. So I think we actually already mentioned that. I've already mentioned in the course of my section. There's an annual report required in respect of each AIF, which should be submitted to the regulator. And the regulator may also ask you to submit, the manager, to submit a detailed list of all the funds which the manager manages at the end of each quarter. And there are also additional disclosure requirements pertaining to leverage, where there is substantial leverage used, which for the purposes of the directive, and this definition means times 3 of NAV. Private equity, there is also some further requirements around firms that are private equity strategies, and particular disclosure requirements therein. So those types of managers will need to consider how to amend their investment and communication processes to meet the directive's requirements to external shareholders of investee companies, fund investors, employees, and even trade unions, and as well as the regulator, when a fund invests in non-listed companies. So in short, a firm must notify the relevant competent authority, either the local authority or the registered office of the investee company, when a firm acquires a major holding or even just a control of a non-listed company. There are numerous thresholds actually, which are 10, 20, 30, 50 and 75%. Each one of those thresholds triggers a notification, and certain information must be relayed to the company shareholders and the FCA within 10 days, and some of the requirements are listed on the slide there. These are quite onerous and can be quite challenging. And actually, also at the top of the slide I didn't mention, the rules do not actually apply for the acquisition of small and medium enterprises, which really small enterprises are those with less than 50 staff and less than 10 million euros on their balance sheet, and whereas medium enterprises is one that has less than 250 employees and 40 million on its balance sheet. And also, it doesn't also apply in respect of certain real estate special purpose vehicles. Also noteworthy, in respect to private equity, is that the directive imposes certain provisions around asset stripping. In essence, the returns on capital or restructuring of capital of portfolio companies that have registered office in EU. So, in short, the obligations here are that any distribution, capital reduction, share redemption, or acquisition by a company of its own shares is not allowed within 24 months of acquisition. Any distributions, moreover, must be made from profits and reserves and must not reduce net assets below paid-up capital. In other words, no asset stripping allowed. So, as my section draws to a close, a little bit of a recap on what the key things are required if a manager wishes to continue marketing in Europe. Some things to think about. Firstly, ensure that you are the manager who is operating in a cooperative jurisdiction. ESMA has established multilateral agreements with all the main jurisdictions worldwide, and at the time of speaking, the FCA has assigned, I think it's 42 bilateral agreements with most of those, if not all now, including all the main jurisdictions of the US, regulators in the US, Japan, Hong Kong, Canada, China, Singapore, Swiss regulator, Australia, Brazil, Dubai, and also with most of the popular fund domiciles like the BVI, Cayman, Bermuda, Guernsey, Jersey and the Isle of Man. Moreover, the fund itself cannot be domiciled in a country listed as a non-cooperative territory by the Financial Action Task Force, FATF. Important for those who may have funds in exotic and strange places like, for example, Ecuador, Indonesia, Pakistan, Tanzania, or even Turkey, which is a bit surprising that's still on there. So one really also needs to ascertain the status of implementation of the AIFMD in the state in which you intend to market, which is really the thrust of my section. So in particular, some key questions that you may wish to ask yourself: have I, the manager, previously marketed there? What nature of investors am I able to market to, which is generally only likely to be professional and institutional? Does the implementation transitional regime in that jurisdiction differ for small and large managers? Oftentimes it does. What, if any, are the filing of registration requirements for marketing? And finally, one really needs to review your marketing strategy and processes. In particular, review your investor list to understand the domicile of your investors. That's very important. Review the use of third-party marketeers, and in particular understand who their contacts are and their target base, and who the investor actually is. And the investor is a specific term under the directive. And finally, probably quite importantly, training for the investor relations team to make sure that they're fully abreast of what the latest status of the rules are. So there is a lot to consider, but I think with a specific strategy, clear marketing strategy, robust processes and capable advisors, you should be able to continue raising assets in the EEA.
Thanks very much, Bobby. I think it's some significant and major challenges for firms there. Now, one of the main benefits of the directive as proposed was, of course, this EU-wide passport, but as Bobby's mentioned, there's no sign of that until 2015 at the earliest. So we do have national private placement, but with add-ons, national regulators have the right to gold plate the directive's requirements, or they may just rewrite the rules and start again. Now, Kathy, from Global Sales Compliance, it sounds like marketing across Europe is going to become more challenging before it gets better. How should firms go about determining what they can and cannot do?
Thank you, John, very much. The question arises from non EEA AIFMs. Is it Fortress Europe for us now? Do we have to stop marketing our funds in the EEA region? And how do we get to grips with understanding what the AIFMD means to us for the purposes of marketing our AIFs in the EEA? And what we can say is, as a general broad comment, the answer is, for the most part, no. It's not Fortress Europe now, but there are some key notable roadblock countries that have already presented certain high-level requirements at day one, and we'll talk about that in a moment. But if we look at how EU directives are generally implemented in the EU, we've tracked EU implementation over the last, let's say, 15 years. And usually, EU directives are implemented on more or less a standard basis at the local level. And each local regulator has the power to implement or tweak pieces of the legislation that apply specifically locally. So in the past, MiFID application or the EU Securities Prospectus Directive was implemented on a rather standard basis. But now we are seeing that AIFMD, as it is implemented in each of the local jurisdictions, is a very divergent implementation approach. In other words, it hasn't been a very settled and standardized implementation approach, at least thus far. And we're just talking about looking at what has happened since July 22nd. So AIFMD was implemented on July 22nd, 2013, this level, in the EEA. And our non-EEA AIFMs ask us, how do we approach understanding what we need to do in each of the EEA jurisdictions? And our approach is a very practical one. First of all, it's a three-step action plan. Number one is stop stop marketing. Number 2 is investigate the local regulations. And number 3 is make a decision on if you can continue marketing in that jurisdiction, or if there are requirements and costs and resourcing associated with it, then you can fine-tune that jurisdiction strategy. So in order to keep costs minimized, we generally advise clients to keep your jurisdiction list on a core focus. You know, the EEA is a large group of jurisdictions. Most of our clients are choosing, say, 10 to 12 jurisdictions that really have live contacts to whom they're marketing their funds and want to market their funds, and they present the largest, let's say, institutional client base. So if you choose your core, let's say 10 to 15 jurisdictions, then you need to investigate on a country-by-country basis based on your specific requirements, and that means the following. Based on the fund, the type of fund, and the type of structure you're marketing, your business model, meaning your licensing model for marketing into that jurisdiction, and your client targets. You need to specify exactly whom you are targeting for the marketing of your AIF. And going down to real specifics, you know, not just institutional investors, but really, do we want to target regulated institutional, regulated professional investors, and do we want to target pension funds, foundations, endowments, family offices? So what we advise is to obtain local advice that is specific to your circumstances as we've described, and then you can do a cost-benefit analysis to determine whether you can carry on marketing under existing transitional provisions, private placement exemptions, or you can uncover whether that jurisdiction looks like it could be a potential roadblock right now. So the time zero for doing this analysis is as of 22nd of July. So July 22nd is when we need to start the analysis. Okay, so AIFMD was quote-unquote implemented on July 22nd. Did all the EEA countries meet that deadline? The answer is no. And this is actually not uncommon in terms of EEA jurisdictions meeting EU directive deadlines. By way of overview, the late EEA jurisdictions that we can mention today are, first of all, Belgium. Belgium's local regulator has not yet produced draft legislation, and they're hopeful to have a draft by December, but it looks like they're implementing it, quote-unquote, at the latest by July 2014. So Belgium only just implemented the EU Securities Prospectus Directive, which was due on July 2012, so that was over a year late. Finland has not met the implementation deadline. We're expecting them to implement it more or less end of December, early January, and that's when the transitional period will begin. Norway also did not meet the deadline. They are also anticipating implementation around 1st of January 2014. It's interesting to note Norway is not scheduling in, at least at this stage, transitional provisions for non-EEA AIFMs. So it'll be interesting to see what will take place as of that date for non-EEA AIFMs. France was also 1 week late, but that had to do with ESMA pushing back on their characterization of closed-end funds under another EU prospectus directive. So this took an additional week to 10 days to work out the discrepancies. And also Italy and Spain are late, but for differing reasons. Both jurisdictions effectively did not have private placement regimes in any case prior to AIFMD implementation. So if we look at, we've established that there have been late implementation EEA states. So if we look at and to demonstrate the divergent approach to how strong the rules are locally as a result of implementation, we can look at least at this stage, a very stringent approach to implementation versus what we would call a liberal approach to implementation. And a stringent approach, we would define that as if we, a non-EEA AIFM, cannot send one 3-pager into a specific EEA jurisdiction until we fully comply with the entire directive right now, including registration, licensing, etc., and there's no transitional period, we would call that stringent. Versus a liberal approach would be a comparatively flexible approach whereby we can carry on marketing under existing private placement rules and maybe avail ourselves of a special carve-out. And to demonstrate the two types of who's got the most stringent laws and who looks to have the most liberal laws, it would be Austria as the most stringent and Holland as the most liberal, at least at this point. Austria has indicated that if managers want to continue marketing their funds after July 22nd, it's full compliance with the AIFMD directive, plus full compliance with local Austrian rules, plus additional requirements on top of that requiring registration and sign off from your home country regulator that you are in full compliance with AIFMD. So it will be very difficult for non-EEA AIFMs to market non-EU 8s in Austria, at least for the considerable time being, versus Holland, which apparently is allowing not only existing private placement to take place, and of course this is after you confirm it with local counsel, but then they've carved out a special, what they call designated states exemption, which permits AIFMs, for example, domiciled in the U.S., regulated by the SEC. So this is a complete carve-out that carves you out of most of the AIFM directive, plus gives you a special waiver on MiFID licensing. So, and this carries you through till 2018. So Holland has taken a very liberal approach versus Austria, which is very stringent. Okay, so transitional periods. What do transitional periods mean? Transitional periods were provided, as John and Bobby have mentioned, in the directive to give you, the manager, some time to, for continuity of business, to carry on marketing in the jurisdictions that permit it, and to investigate what your requirements are before the transitional period ends. So how do we know if we qualify and where the transitional periods are? Well, that's a 3-part check. So first check is you have to check and see if there is a transitional period in that jurisdiction and when does it start. So as we mentioned earlier, for example, in some of the countries that started or that have not implemented AIFMD yet, like, for example, Finland, the transitional period will start when they implement AIFMD. So if that's in January, then the transitional period is January to July 2014. So you have to ask, is there a local transitional period, and what's the duration of that period? Secondly, you need to ask, are the transitional periods available to non-EEA AIFMs? Because not all of them are available to non-EEA AIFMs. As we mentioned, it looks like Norway is not writing in that special allowance. At least that's the way the legislation looks for the moment. And then, do we qualify? You have to be eligible for these transitional periods, and that means you need to be conducting, quote, fund solicitation or conducting business in the EEA jurisdiction prior to July 22nd, 2013. So what does that mean? Well, there's no concrete definition, but most of the law firms generally advised the industry to send your client prospect list in the EEA key documents in order for them to subscribe to your fund before the 22nd of July. So let's say if you have a limited partnership fund, then you should send out the PPM, the subscription doc, and the limited partnership agreement before the 22nd of July, 2013. So that's a three-part check. So then the next check that you need to examine, once again on a country-by-country approach, is are the private placement rules available to me during this transitional period if available, or just generally right now. Now, what we are observing as AIFMD is settling in on the local level is that the old private placement rules coexisting with the new AIFM rule regime, in some jurisdictions it's a bit of a struggle by the local regulator to have these two regimes coexist. We are seeing seamless coexistence, plus we're seeing overlays of AIFM that kind of rule out what private placement said before, and there's a new definition of it's a professional investor. We're also seeing that under the new, what we would call private placement with AIFM included, some local regulations are tying in their local COB rules, their conduct of business rules, if you're targeting professional investors versus non-PIs. What we're also seeing is gold-plating provisions tend to be implemented in jurisdictions where you want to target non-professional investors. And some of the other observations we're seeing is our professional investors are being carved up in that it's no longer a case of, well, we want to market to qualified investors and it's an institution, end of story. Regulators have endeavored to carve out some professional investors that are not regulated, like pension funds, like endowments, like foundations, trusts, and definitely family offices, to put those in a different category called semi-professional investors or non-PIs. So usually we're seeing gold-plating provisions if you want to market to the protected institutional investors within professional investors or individuals or non-PIs. And then we're also seeing a bit of a struggle as it relates to product characterization rules. The old product characterization rules are starting to be phased out to where, you know, to determine what private placement rules apply for your fund, prior to July 22nd, the question was, well, what is it characterized as? And based on its characterization, which is tied to its structure, we can know whether the fund rules apply or the securities laws apply. So these product characterization rules are kind of getting phased out. Do other EU-wide directives still apply in tandem with AIFMD as of July 22nd? And the answer is it's best to check it on a country-by-country basis. But on a broad level, we would say, yes, the MiFID licensing regime still applies. So, and this would cover your fund solicitation activity, which is falls under the provision of investment services under MiFID licensing. However, a carve-out that we mentioned earlier is in the Netherlands, under this special new exemption, the designated states exemption, they're going to waive MiFID licensing for U.S. managers that are regulated by the SEC. So, you know, it's best to just recheck everything in each jurisdiction. Do we need a license to market? What are the AIFMD requirements, the private placement exemptions, and the transitional provisions? And then we're seeing the EU Securities Prospectus Directive, which governed funds, let's say AIFs, in some jurisdictions, closed-end AIFs, for example, real estate funds or private equity funds, in some jurisdictions fell under that special EU Securities Prospectus Directive, which used to be a very robust private placement exemption regime because under the minimum investment of 100,000 euros option under that directive, you could market to an unlimited number of investors. For example, in France, and that was the case for about the past 5 years. These sorts of loopholes are getting slowly close, to where ESMA has pushed back and said, no, you've got to include closed-end funds as an AIF, and it's got to be subject to the AIFMD. So one of the concepts that law firms are mentioning is the use of what they're calling, quote, reverse solicitation. Now, we call reverse solicitation documented reverse inquiry, or DRE. Why? Because reverse solicitation is not provable unless it's documented. So it's always got to be documented. So let's talk about what this concept is and if it's kind of a safe green light for you to use. Reverse inquiry, documented reverse inquiry is a concept. It's a rebuttable presumption that you, the AIFM, have to always prove at any point in time that you are not marketing. So the presumption is always that you are marketing unless you can prove otherwise. So generally what regulators apply to confirm if you can really be considered to fall under reverse solicitation is the initiative test. And that is who contacted whom first. And in a clean instance of what is a clean reverse inquiry, you would be sitting at your desk, the phone rings, an investor calls you up completely unprompted and not as a result of prior solicitation, and wants to invest in your fund as a result of their own specific research that they did on Bloomberg or on some kind of research that they've done, and sends you an email to say send them some documentation on your fund. That would be a clean and easy documented reverse inquiry instance where you could print out that email, you could put it to your sales compliance file, and if there's ever a question, you really can prove that that was a reverse inquiry. Now, we know that life doesn't always work that way, and these types of completely unsolicited inquiries constitute maybe 1 or 2% of what actually happens on a daily basis. What we tend to find is that funds that have a long marketing cycle, like closed-end funds, for example, private equity or real estate funds, where you have a very high minimum investment, and you have to do years' worth of marketing to the end client to get them comfortable with your strategy, with committing $5 million. These long marketing cycle type funds, it's very difficult to prove who contacted whom, because in the interim time period, there are fly-in visits to the local jurisdiction, and there's an ongoing relationship that you're building. What we tend to see is the cleanest account of reverse inquiry is usually with our open-ended fund UCITS clients who, will get unsolicited emails that come into their corporate email inbox and say, we've reviewed your strategy, we like it, we want to invest. So if you do receive a real reverse inquiry, then how do you document it? Well, you have to document, ideally, it in writing. So you need to document or print out the email or the fax or whatever written request it was that the investor sent you to ask you about your fund, and it is extremely important to document it. I'll give you a real live example of what can go wrong if you don't document it. Our French law firm has just worked on a litigation case where a French institution asked a U.S. hedge fund manager, real reverse inquiry, we like your strategy, send us the PPM on your fund. The manager in the U.S. sent the PPM into France. It was a reverse inquiry, but the manager did not document anything to the file. The investor became disgruntled over time due to performance, or they just weren't happy, and they exercised rescission rights and also filed litigation. So, even if you do have a real reverse inquiry, you have to document it, and you have to document it with very careful records. Now, how can DRE go wrong? Is DRE a safe harbor? The answer is no. In practice, no, it's not. It's not a private placement exemption or a green light for waiving all licensing or AIFMD requirements. It is only a quasi-private placement exemption in Switzerland, which has always been in the legislation. And so you shouldn't consider it to be a safe harbor. And we advise clients to use DRE on a very sparingly basis. You should always comply in the first instance. But, from time to time, you may well have real cases of reverse solicitation. But always document it, have strong sales compliance files, because what can go wrong is when investors get angry. And they will get angry when they lose money or there's a market crash. And the first thing they will claim is, you sold that product to me in breach of local private placement rules or AIFMD requirements. You're in breach of AIFMD. You're also in breach of licensing requirements. I'm going to sue you. I want my money back. And that's what we always see. And what we've also, we have a lot of experience in querying local regulator views on reverse inquiry. And it's interesting, before AIFMD came into play, we had heard from our lawyers, our UK lawyers, that the the old FSA, did not believe that reverse inquiry actually happens in practice. So some regulators will look through the practice and will look down to the substance of your activities, which you have to prove. So is reverse solicitation a green light and a fallback position that we can take to avoid all the regulations in the EEA? Our position is no, and you should be very, very cautious with using reverse solicitation. So, in summary, we would say that AIFMD is kind of causing a revolution in the EEA. This is what our French lawyers told us. It's a revolution. It's changing the face of European regulation as it pertains to private placement and other parallel EU regulations. Also, it's interesting to see that implementation locally is very much influenced by politics and key economic stakeholders. Holland is a very good example. One of the key reasons why they're taking such a liberal approach to AIFMD implementation for some type managers is because of the 80 billion euro pension fund industry that lobbied the AFM very hard to write in some key carve-outs to the legislation to make it less difficult for them to access managers, particularly in the U.S. It's also important to note that, some U.S. or non EEA managers may think, well, that's far away, it's not really impacting me. But, be assured that with this new legislation, the local regulators are writing into their legislation locally sanctions that were similar to the sanctions that were in place for private placement, and many of those sanctions involve criminal sanctions, so imprisonment on the books, which can apply to company management, salespeople. You can also expect to see litigation risk increasing across the EEA for non-compliant managers, which is all tied into rescission rights risk, business risk, franchise risk, and reputation risk. So it is important, is the EEA a fortress Europe? Not necessarily, not if you comply. But if you don't, then it will and very well could be a fortress Europe. So what's the future outlook? From 2013 to 2018, it's important to note that the implementation of AIFMD locally is an evolving process. The regulators are still working on fine-tuning the local specific application, so it's important to keep up to speed with the local regulation and the changes. We're telling clients fasten your seatbelts. It's going to be a bumpy ride from here till 2018. But it's important to take good, reliable local advice and comply, and you'll be fine.
Thanks very much, Kathy. Just one thing I'd like to pick up before we sort of move to the close is a lot of our clients here have a MiFID firm which is able to promote its management of segregated accounts, managed accounts, and that has its own passports. And so I wonder whether we've been asked sometimes, if they're out talking about investment management services, can, and the subject of funds come up, is that reverse solicitation of this inquiry, is that acceptable? Is that approach acceptable?
Well, that's a very good question, John, and it raises complex issues, and it's important to look at it, as we've said, on a country-by-country basis. But if we talk about the managed account business, if I want to do managed accounts under a MiFID passport in the EEA, first of all, I have to remember that managed accounts, and I would assume we mean managed accounts managed under a discretionary investment management agreement. This is subject to three-way licensing. So I need a license to market it, I need a license to manage it, potentially, and I need a license to conduct after-sale client servicing, because I, of course, want to get on a plane and fly into Belgium and service the account afterwards. Now, during that discussion of talking about my capabilities or my managed account services, yes, it's likely that the client could say, well, I don't want to commit $20 million to a managed account. Do you have a fund that I could invest with a similar strategy with lower minimum investment? We would say to clients to be very careful with that approach, considering it a carve-out, because and it's almost safer to say no, it's not a carve-out, although it's very fact-specific and it's very country-specific. We would say definitely do not use that approach in France, because we've had French counsel confirm it in writing that you cannot market your managed accounts as a free pass to get your funds in the back door. So we would say, our position would be, of course, the most prudent position, which is check it on a country-by-country basis, but assume the answer is no, and you're going to comply with AIFMD on the fund side.
Thanks very much, Kathy. So I think there are some important messages there about knowing the status of the AIFMD implementation and the transitional provisions in your jurisdiction that you're planning to market in, complying with these rules that Bobby talks about in terms of disclosure and the reporting, and particularly this systemic reporting, and preparing to meet those obligations when they come due. The European legislators are also looking, as Kathy mentions, to enforce their regimes with sanctions against non-compliance with the private placement regimes. And there's litigation risk, as Kathy mentioned as well, in terms of the risk through non-compliance and investors claiming that their funds were missold. And I think there is a picture, unfortunately, of this kind of continuing uncertainty around marketing throughout, certainly to 2015 and then beyond 2018. So if you have further questions following this webinar, then please feel free to contact any one of us. Our contact details are shown here. There will be a survey available following the webinar, which we'd like you to participate in, just some questions to deal with and to answer, which we'd like to get your thoughts on. I'd like to thank our presenters today, Bobby Jahal from Cordium and Kathy Brand from Global Sales Compliance. I'd like to thank Louise Yates for the marketing and preparation of this webinar, and thank you all for listening in, for linking in and listening in to our webinar today. Thank you and goodbye.